in case 23 CR 103, State of Ohio versus Chandra L. Spidell. We are here today for purposes of an information hearing. Defendant is present, represented by attorney Mary Springer. It is the state's understanding that the defendant is going to enter a plea to both counts in the information, possession of marijuana, a felony of the 5th degree, as well as OVI, a misdemeanor of the 1st degree. Pursuant to the plea negotiations between the state of Ohio and defense counsel, the state has committed to reviewing the pre-sentence report and any other evaluations prior to committing to a sentencing recommendation, but we did indicate that we would likely recommend a prison sentence in this case, Your Honor.
Thank you. Springer, does that all sound accurate?
Yes, it does.
Spidell or Speedo?
Spidell.
Spidell. Mr. Spidell, were you able to hear what was just said by the prosecutor regarding what they believe your intentions are here today?
Yes, Your Honor.
It was indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'll explain in more detail what that means here in a second. And to go ahead and plead guilty then to the 2 charges in the information, which I will also review with you to make sure you understand them. We would then continue the sentencing to a later date to get some evaluations completed, come back on a future date for sentencing. Where there is no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to I got to sneeze, I'm sorry. I'm going to have to ask you here, before I can accept your plea, a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right? You have to verbalize your answers to the court reporter.
Okay.
All right, let's get started then. How old are you, sir?
28.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into the court here today, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication? Nothing?
No, Your Honor.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges you're accused of committing and what you're pleading guilty to?
Yes, Your Honor.
You had a chance to look that over?
Yes, Your Honor.
Now, in that information, you are charged with 2 counts. And count 1, what's alleged here, this is what you'll be admitting to, is on or about November 24th, 2022 in Willoughby Lake County, Ohio, that you did knowingly obtain, possess, or use marijuana or a mixture, preparation, substance, or compound containing marijuana. The amount of marijuana is alleged to be equal to or greater than 200 grams, but less than 1,000 grams, specifically 554.16 grams, which makes the offense possession of marijuana a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, this count also carries with it what we call a forfeiture specification, which alleges that during the commission of the offense, you possessed or had an interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal to possess just because it's illegal, whereas an instrumentality, the property is not necessarily illegal, but it's being used in an illegal manner to facilitate a crime, and you're not allowed to possess it for that reason. And in this case, it's alleged there's the marijuana itself, along with scales and plastic bags. And the whole point of this specification is that you just forfeit, at the time of sentencing, any right you have to that property. Do you understand that?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, in count 2, what's alleged here is on or about November 24th, 2022 in Willoughby Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. That conduct is the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's a misdemeanor in the 1st degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Well, then, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. You first of all have a right to have this case presented to a grand jury. So those charges I just read it to you are part of what's called an information. An information are criminal charges that are brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether a probable cause exists that a person committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a crime. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can also give up that right if you desire and go forward in the charge brought by the prosecutor, and your attorney has indicated she believes that's what you want to do. Is that correct?
Yes, Your Honor.
Before I can go further, I need to have you acknowledge that here in open court in writing. I have in my possession here a one-page document called a waiver of indictment, which basically sets forth what I've just explained to you about the grand jury process and that you want to give that right up. My understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mrs. Springer, is that accurate? Did you read this to your client and go over with him?
Yes, I did.
Did he indicate an understanding of it to you?
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
And did you in fact sign the document?
Yes,
It
Your
appears
Honor.
that you did. Did you sign it?
Yes, Your
Can
Honor.
you witness that, Ms. Springer?
Yes, Your Honor.
Mrs. Lee?
I did, Your Honor.
All right, then that document will be made part of the record, and at this point, I am going to go over all the other rights you have that you're giving up by pleading guilty. And you first of all have a right to have a trial. And that trial could be, to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make the ultimate decision. And that ultimate decision reached by the 12 jurors would have to be unanimous. What that means is all 12 of them would have to agree together, one way or the other, guilty or not guilty, as to each separate charge. You understand that?
Yes, Your Honor.
You understand by pleading guilty or giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, by her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of this charge, both charges, and the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since it's a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty at a trial. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, if we're going to have a trial, the prosecutor will bring witnesses that come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. We call that cross-examination. She can ask them anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court and testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come into court and testify for you and answer your lawyer's questions if they were not willing to do so voluntarily. Do you understand that?
Yes, Your
Do you
Honor.
realize you're giving up that right?
Yes, Your Honor.
You'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, she's not allowed to call you as a witness at your trial and force you to get up on the stand and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
You understand that your guilty plea is a complete admission of guilt. It means you're admitting to the facts that are being alleged here. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you'll subsequently, on another day, be sentenced by the court. Do you
Yes,
understand
Your
that?
Honor.
Now, as far as sentencing goes, you are pleading guilty in count one to a felony of the 5th degree. This offense carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, count two, the OVI charge is a misdemeanor. It's a misdemeanor of the 1st degree. This offense carries with it a mandatory term of local incarceration in the county jail of at least 3 days, and it could be up to 180 days. Do you understand that?
Yes, Your Honor.
Now, if this court were to impose a prison sentence on the felony charge in count one, the marijuana charge, any sentence imposed on the OVI charge, since it's a misdemeanor, would have to be served and run concurrent with the prison term. Concurrent means you serve them together at the same time versus consecutive, which you would serve one and then the other. You understand the difference there?
Yes, Your Honor.
This court is not permitted, I do not have the authority to run a jail sentence consecutive to a prison sentence. You understand that?
Yes, Your Honor.
So the maximum sentence you face in this case with these two charges is 12 months in prison. You understand that?
Yes, Your Honor.
Now, do you have any other charges pending against you right now anywhere else?
No, Your Honor.
Are you currently, or were you at the time on probation or post-release control?
Post-release control.
How much longer do you have on that, if you know?
2 years.
I do need to advise you that a person who is on post-release control, if they commit a new felony while on PRC, the judge who is sentencing them on the new felony, even if it wasn't the same judge that had the case that you're on PRC for, I would have the discretion at this time, at sentencing, I should say, to terminate or end your post-release control and impose an additional prison term of either 12 months or the amount of time you have left on PRC, whichever is greater. So if you're saying you have approximately 2 years left, I could impose up to 2 years prison term for committing a new felony while in post-release control, and it would have to be served consecutive to whatever prison term was given on the marijuana charge. You understand that?
Yes, Your Honor.
So if the 2 years is accurate that you said you are facing here, now that's not mandatory or required. I don't have to do that, but I have the right to do that. You're facing 3 years in prison. You understand that?
Yes, Your Honor.
Now, in this case, if a prison sentence is imposed for the marijuana charge, upon your release from prison, you could be placed on post-release control for this case for up to 2 years. It's not mandatory, but it's up to the parole authority to determine that. But it could be up to 2 years, and if you are put on post-release control, and you're violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
In addition to the prison term I just mentioned, there's other sanctions that could be ordered. If you were to pay court costs or reimburse the county for any cost of confinement, community supervision or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
There's also a possible fine on the marijuana charge of up to $2,500. You understand that?
Yes, Your Honor.
On the OVI charge, there's a mandatory fine that I'm required to impose of at least $375. I could fine you up to $1,075. Do you understand that?
Yes, Your Honor.
So altogether, there's a fine that will be imposed with both of these counts of at least $375 and could be fined up to $3,575. You understand that?
Yes, Your Honor.
There's also mandatory license suspension I'll be required to impose on the OVI charge. It's anywhere from 1 to 3 years, and on the drug charge, it's mandatory, and it's up to 5 years. So anywhere up to 5 years. You understand that?
Yes, Your Honor.
Also, as I alluded to earlier regarding that forfeiture specification, you will forfeit any right you have to the property that I listed before. I think it was marijuana, bag, and something else. I can't remember. Whatever the contraband was, you'll forfeit your right to that. Oh, scales. You understand that?
Yes, Your Honor.
All right, now a few moments ago I explained the possible prison sentence you face. I did use the word possible because prison's not mandatory in this case. You are eligible for probation, what we call community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you automatically be put on probation? It means I will consider it if that's what you're asking for. I'm going to look at all the information that gets presented. Then I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be up to 5 years, and as the judge, I would have the discretion to order a wide variety of rules and conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months. You understand that?
Yes, Your Honor.
Further, if you're put on probation and you ever violate any of the conditions of your supervision, we will have a hearing to see if you're what's called a probation violator, and if it's determined that you are, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did it at that point, again, it could be 6 to 12 months in prison on count one. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the attorneys have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your attorney and have her review the reports with you, discuss the issues, answer your questions?
Yes, Your Honor.
Are you satisfied with her advice and counsel?
Yes, Your Honor.
Has she, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your plea freely and voluntarily?
Yes, Your Honor.
Then, sorry?
Freely?
Okay. Well,
Yeah.
okay. No one's forcing you to do this?
No,
or
no, Your Honor.
pressuring you to do this or anything like that?
No, Your Honor.
All right, then. Do you have any questions for me at this time regarding anything we've talked about, the rights you're giving up, penalties you face, what you're pleading to? Any questions at all?
No, Your Honor.
You need any more time to speak with your attorney?
No,
Are you
Your
under
Honor.
your plea?
No.
All right, then what's going to happen at this time, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I need you to listen to what she says because then I'll have some questions for you, all right?
Okay, Your Honor.
Mrs. Zurich?
Thank you, Your Honor. Had this case gone to trial, the evidence would have shown that on November 24th of 2022 in Willoughby, Lake County, Ohio, the Willoughby police responded to the garage bar for a disturbance. The defendant was found in his vehicle to have 554.16 grams of marijuana. He was also found to have scales and plastic bags in his possession. As the result of the investigation, he was found also to be driving his vehicle under the influence of alcohol. He did submit to a breath test, and the results showed that his BRAC was 0.176.
Sir, were you able to hear what the prosecutor just had to say regarding what she believed the evidence would show if we had a trial?
Yes, Your Honor.
And what, if anything, did they say about those facts as she presented them? Are they true? Did you do as she said?
Yes, Your Honor.
Very well, then, regarding count one, charging with possession of marijuana, felony of the 5th degree, with the forfeiture specification, what is your plea to that?
Guilty, Your Honor.
And regarding count two, charging with operating a vehicle under the influence of alcohol, or drug of abuse, or a combination of them, a misdemeanor of the 1st degree, what is your plea to that?
Guilty, Your Honor.
All right, I have in my possession now another document. This is 4 pages, which sets forth everything we've just talked about. Before I can accept your plea, I need to make sure you understand what's in this document, that, again, you've signed it here in court. My understanding, again, is that before I came out here, you had a chance to go over this with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Springer, is that accurate? Did you read this to your client and review it with him?
Yes, I did.
Did he indicate an understanding of it to you?
Yes, Your Honor.
Is that correct, Mr. Spidell?
Yes, Your Honor.
Do you have any questions for me about what it says?
No, Your Honor.
Now, it appears in the bottom of the third page here that you signed the document. Did you, in fact, sign it?
Yes, Your Honor.
Ms. Springer, you witnessed that?
Yes, I did.
Mrs. Zuri?
I did.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept your plea, find the defendant guilty of count 1, possession of marijuana, felony to the 5th degree in violation of 292511, with the forfeiture specification, and count 2, operating a vehicle in the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree in violation of 4511-19A1A. I will defer sentencing, order of pre-sentence report investigation, drug and alcohol evaluation, continued bond at $5,000, cash surety 10%. I think that's everything. Is there anything else for the record, Ms. Azuri?
I don't believe so, Your Honor.
Ms. Springer?
No, Your Honor.
All right, thank you.
All rise.
We're before the court this morning in the matter of the State of Ohio versus Dominic J. Corey, case number 22 CR 789. The defendant is present in the courtroom with his attorney, Mr. James Matthews. We're here for purposes of a change of plea in accordance with the plea agreement that's been reached between the parties. And if it pleases the court, at this time I put the terms of that agreement on the record.
Please.
Pursuant to the agreement, Your Honor, the defendant would be pleading guilty to count 2 and count 3 in this matter. Count 2 is a carry and conceal weapons felony of the 4th degree for one gun, that being the Smith & Wesson pistol. Count 3 is a felony of the 4th degree, improperly handling firearms in a motor vehicle count. That relates to a second firearm the defendant had this day. It's a polymer Glock 80 pistol. Upon the condition of those guilty pleas being forthcoming, accepted by the court after findings of guilt at the time of sentencing, the state would move to dismiss the remainder of the counts in the indictment. The defendant has agreed to voluntarily forfeit those firearms and also some cartridges and magazines, other items that were seized by the police at the time of the arrest. The state would review the pre-sentence report prior to making its sentencing recommendation. I would put on the record at this time the state is already aware that the defendant has a juvenile adjudication involving a firearm, so that's not going to be a shock to the state later. The state expects the defendant's going to request community control sanctions. That's it. Thank you.
Thank you. Mr. Matthews, is that accurate?
Yes, Your Honor.
And pronounce your last name for me, please.
Corey.
Corey?
Yes, sir.
Is that right? Were you able to hear what was just said by the prosecutor regarding what they believe your intentions are here at this time?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previously entered pleas of not guilty to counts 2 and 3 and plead guilty to those charges. Counts 1 and 4 would then get dismissed pursuant to the agreement. We would then continue the sentencing to a later day to get some reports and evaluations completed, come back on a future day where there's no agreement between the parties regarding any recommendations for sentencing. Each side's free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. Excuse me. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Let's get started then, sir. How old are you?
20.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you had any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
I probably drank a little bit yesterday.
Okay. You probably did?
Yeah, I drank like a shot yesterday.
Okay. What time was that about?
On the early side.
Okay. Well, the reason I'm asking, I want to make sure that you're not under the influence of anything right now, whether
Yeah,
it's
I'm sober
illegal
right now.
drugs or alcohol, prescribed medication, anything that's making it difficult for you to understand or appreciate where you are, what's going on, anything like that.
All right.
So are you currently under the influence of alcohol right now?
No, sir.
And when I asked you about if you've had any drugs or alcohol in the last 48 hours, I'm referring to even prescribed medications. Anything there?
No, sir.
So you're clear mind right now. You're not negatively impacted by any type of substances, which is making it difficult to appreciate your surroundings?
Correct.
All right. Now, you would have been served with a copy of the indictment in this case. You got it, looks like end of December, beginning of January. Do you remember getting that, the document that sets forth what the 4 charges are?
Yes, sir.
Did you have a chance to look that over at some point?
Yes.
Now, in that indictment, You are charged with 4 counts, and what's alleged here, hang on one second. What's alleged here in count 2 is on or about July 2nd, 2022 in Lake County, Ohio, that you did knowingly carry or have concealed ready at hand a handgun other than a dangerous ordinance, specifically a Smith & Wesson pistol. The firearm is also, the weapon involved was a firearm that was loaded or for which it's alleged you had ammunition ready at hand. That conduct constitutes the offense of carrying concealed weapons. It's a felony of the 4th degree. Do you understand what you're charged with in pleading guilty to in regards to count 2?
Yes, sir.
Any questions about it?
No, sir.
Now, count 3 alleges on or about that same day, July 2nd, 2022, in Lake County, Ohio, that you did knowingly transport or have a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator without leaving the vehicle. That conduct constitutes the offense of improperly handling firearms in a motor vehicle. It's a felony of the 4th degree. And this count references a different firearm from the firearm in count 2, correct?
Yes, Your Honor.
Do you understand what's alleged here in count 3?
Yes, sir.
Any questions about that?
No, sir.
Now, there are 2 other counts in the indictment. Those are both being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about either of those 2?
No.
Well, then, before I can accept your plea of guilty to counts 2 and 3 that I just read to you, I need to make sure you understand all the rights you're giving up. And you, first of all, have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors will consider and weigh all that evidence, and then those 12 jurors will make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together one way or the other as to each charge, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Now, by him having the burden of proof, what that actually means, it's his job, or he bears the responsibility, the obligation. He bears the burden of proving you guilty before you could ever be found guilty. You're presumed innocent of the charges, and the presumption sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since it's a criminal case that we have here, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal charges that I just read to you beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes, sir.
Any questions about that?
No.
So do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. So he'd be allowed to ask them anything he wanted to, within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come in court and testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yeah.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come into court and testify for you and answer your lawyer's questions if they were not willing to do so voluntarily. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else can force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes, sir.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. So what that means is you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or that it's someone else's fault or anything like that. Do you understand that?
Yeah.
Further, as a result of pleading guilty, the effect of the guilty plea is you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yeah.
Now, as far as sentencing goes, you're pleading guilty to 2 felonies of the 4th degree. They're each punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, since there are 2 separate charges here and it relates to 2 separate guns or firearms, if I did impose a prison sentence, I would impose it on each count. And then as the judge, I do have the discretion to run those sentences either concurrent or consecutive to each other. Concurrent means you serve them together at the same time, whereas consecutive is one after the other. You serve the term on count 2, finish that, then serve the term on count 3. Understand the difference there?
Yeah.
So in this case, if I impose the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term of 36 months or 3 years in prison. Do you understand that?
Yes, sir.
Are you currently on probation or parole, post-release control to any other courts or agencies?
No, sir.
Do you have any other criminal charges pending against you anywhere?
I have a case in Cuyotta.
What kind of case?
It's a gun case.
Is it a felony charge?
Yeah, the charge is a felony charge.
Okay. The reason I ask that is if you are sentenced to a prison term in another case before you come back here for sentencing, I don't know what the status of that case is. Has it been resolved at all yet?
It's coming to a resolution.
Well, if you're sentenced to a prison term in that case before you come back here for sentencing, if I impose a prison sentence, I can run my sentence concurrent or consecutive to that.
Right.
But I can only do that if you've already been sentenced. I can't do that if you have not been sentenced in another case. I can't sentence you and say, oh, my sentence is going to be consecutive to some future possible case out of Cuyahoga County. I'm not allowed to do that. It's got to already be imposed. You understand that? Yeah. Now, if a prison sentence is imposed in this case, upon your release from prison, you could be placed on what we call post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence, and it could be for up to, in this case, 2 years. You understand that?
Yeah. Yes. So you saying, let's say I did 3 years in prison, I get out and I'll be on parole for 2 more years.
Not necessarily. It's not mandatory or required. It's up to the parole authority to decide that. So parole, which is what most people refer to it as, it's what's really called post-release control. It's optional, but it's up to the parole authority to decide if they're going to do that. I don't have any say in that.
Okay.
So yes, it could happen, but it's not automatic or required. And it could be that you're on for 1 year or 6 months. It could be up to 2 years.
Okay.
But it could be no time. It's up to the parole authority to decide that. You understand that?
Yeah.
And that could be whether the sentence is 3 years or whether it's the minimum, 6 months. Either way. You understand that?
Yes, sir.
You can get a 6-month sentence and still be put on post-release control for up to 2 years. You understand that?
Yeah.
Now, if you are put on post-release control and you ever violate the conditions of your supervision, the parole authority could send you back to prison as punishment for not following their rules for another 9 months for each separate parole violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. You understand that?
Yes, sir.
Any question about that?
No.
Now, in addition to the possible prison time, there's other sanctions that could be ordered. You could be fined in this case. Each count carries with it a possible fine of up to $5,000. So together, there's a maximum possible fine of $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, sir.
You will also be forfeiting any right you have to the 2 firearms that were seized during the investigation. You understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I did use the word possible because prison is not mandatory in this case. You are eligible for probation, what is referred to as community control sanctions. Do you understand that?
Yes, sir.
You understand that just because you're eligible doesn't mean you'll automatically be put on probation. It means I'll consider that if that's what you're asking for. I'm going to look at all the information that gets presented to the court. Then I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
Yes, sir.
If you are put on probation, it could be up to 5 years, and as the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
So I go to jail for 6 months and then go on probation.
No, it starts at the same time. So if I put you on probation at sentencing, your probation would start on that day.
Okay.
So say it was 2 years of probation, it'd be 2 years from that day that you'd be on. But as a condition of probation, it's not required, but I could sentence you, order as one of the conditions that you serve 30, 60, 90 days in the Lake County Jail, up to possibly 6 months as a condition of probation. Now, you're on probation during that 60 days. Obviously, you can't, when you're in jail, comply with all the conditions. You're not going to be able to report to your probation officer and do other things that you would be doing once you're out. But the probation would start on that day. So I guess what the point I want to stress also, though, is just because you get probation doesn't mean there's necessarily no incarceration. There could still be local incarceration in the Lake County Jail. You understand that?
Yes, sir.
Any other questions about that? No. Now, if you are put on probation to the court and you violate any of the conditions of your probation, we'll have a hearing here in court to see if you're what's called a probation violator. If it's determined that you are, I could extend your probation up to 5 years if it wasn't initially 5 years. I can impose more restrictive sanctions against you, including an order that you serve time in our Lake County Jail, or I could terminate your probation at that point and send you to prison then. If I did it at that point, again, it could be in that same range I mentioned before, 6 to 18 months in each count, could be consecutive, so possibly 3 years. Do you understand that?
Yes, sir.
Lastly, when we do proceed to sentencing, you will have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf and recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. And I'm not required to go along and follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No.
You understand all the possible sentences?
Yes, sir.
You still want to plead guilty?
Yes, sir.
Have you had enough time to talk about the case with your lawyer, have him review the report with you, discuss the issues, and answer your questions?
Yes, sir.
Are you satisfied with the advice and counsel of your attorney?
Yes, sir.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here?
No, sir.
Have you been threatened or forced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then, do you have any questions for me at this time regarding anything we just talked about, what you're pleading guilty to, the rights you're giving up, possible penalties you face, any questions at all?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with your actual plea of guilty?
No, sir.
All right, then what's going to happen at this point? The prosecutor here, he's going to explain for me what he believes the evidence in the case would establish if we did have a trial. I want you to listen to what he says, because now I have some questions for you about that, all right?
Okay.
Shapiro?
Thank you, Your Honor. Your Honor, on July 2nd, 2022, in the city of Wickliffe, Lake County, Ohio, the defendant was driving southbound on Lloyd Road. A Wickliffe police officer observed a number of moving violations and also that the defendant's license plates were expired. Incident to a traffic stop, the officers found two loaded firearms inside the defendant's vehicle. One was underneath the seat, the passenger side front seat. One of the officers was able to see the barrel of that, but it was concealed underneath the front seat. That would be the Smith & Wesson pistol. And then also, Your Honor, on the left rear floorboard in the back seat of the car, there was a small canvas black zip, like bag that contained a second loaded firearm. This was a polymer 80 pistol with a Glock slide and a barrel on it. Inside that bag was also the defendant's identification. The defendant provided a DNA swab. There was DNA found on both of these guns that matched the defendant. The defendant was 19 years old at the time of this offense as well, Your Honor. Both of these firearms were loaded and operable. The polymer 80 in the back seat was accessible to the defendant as he drove inside the car. Thank you.
Mr. Corey, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, good to say about those facts he presented them? Are they true? Did you do what he said?
Did I do what?
Did you possess those firearms in the manner that he said and where they were?
Yes, sir.
Very well, then, regarding count 2, charging you with carrying concealed weapons of felony to the 4th degree, what is your plea to that?
Guilty.
Regarding count 3, charging with improperly handling firearms in a motor vehicle of felony to the 4th degree, what is your plea to that?
Guilty.
All right, I have in my possession at this time a 4-page document which sets forth everything we just talked about. Before I can accept your plea, I need to make sure you understand what's in this document and you signed it here in open court. Now, my understanding is before you came in here, you had a chance to go over that document with your lawyer. Is that correct?
Oh, what?
This 4-page document setting forth your rights and possible penalties and everything?
Yes, sir.
Did you read it before I came out here?
Yes, sir.
And your lawyer went over it with you?
Yes, sir.
Is that correct, Mr. Matthews?
It is, Your Honor.
And in going over it with him, did he indicate an understanding of it to you?
He did.
Do you understand it, Mr. Corey?
Yes, I do.
Any questions for me about what it says?
No.
Now, on the top of the last page here, it appears that you signed this document. Did you sign it?
Yes, sir.
Did you witness that, Mr. Matthews?
I did, Your Honor.
Mr. DeCuro?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 2, carrying concealed weapons, a felony of the 4th degree, in violation of revised code section 2923.12A2, as well as count 3, improperly handling firearms in a motor vehicle, a felony of the 4th degree, in violation of 2923.16B. I will dismiss counts 1 and 4 at the time of sentencing, but sentencing will be deferred. I'm going to order a pre-sentence report investigation, continued bond at $3,500, cash surety or 10%. Any of the reports you're requesting?
No, Your Honor.
So what all this means, Mr. Corey, as far as at this point, as far as bond goes, haven't made any changes. So you've already posted your bond, and there's nothing more you need to do, except you need to continue complying with the conditions of your bond. Now, one of those conditions of your bond has been and will continue to be that you don't use any drugs while on bond. You'll have to submit urine screens if requested. If they should come back positive, your bond would be revoked and a warrant would be issued for your arrest. Do you understand that?
Yes, sir.
Now, the report that I've ordered, the purpose of that is so I can learn more about you before sentencing. And the way the probation department gets that information is they're going to conduct an interview with you. It's important that you show up on time when scheduled at the probation department for the purpose of that interview. Because if they can't conduct the interview because you didn't show up or you're not cooperating with them, they can't complete a report. And without a report, the law doesn't even allow me to consider probation as an option at sentencing. Do you understand that?
Yes, sir.
All right, so you're going to leave here right now. You're going to go to the probation department. You're going to meet with them, fill out some initial paperwork, and get your date to come back for that interview. So make sure you go over there right from here, all right?
Okay.
All right. Mr. Pirro, anything else?
I do have one thing that I need to bring to the court's attention, Your Honor. It was mentioned earlier in the hearing that the defendant does have a pending felony level case in Cuyahoga County That is also an F4 CCW and an F4 improper handling. The defendant was indicted in October, and he, while he was on bond in this case. So I need to bring that to the court's attention. One of the bond conditions here always is that he not be charged with a new offense, but also there's a specific no firearm condition here, so I'm bringing it to the court's attention. He has this indictment.
Usually, I mean, a motion's filed if there's something that wants to be done. I didn't get it. There's been nothing filed in this case.
I did not know about this, Your Honor, and that's why I didn't file a motion. But I didn't. I feel that I at least need to bring it to the court's
Fair enough.
attention.
Thank you. Mr. Matthews, anything else?
Nothing further, Your Honor. Thank
All
you.
right.
Stay standing.
You can sit.
Oh, okay.
So, I'm just standing. So
I'm
my hand is
hooked on the chair. My mom has bad knees. Sorry.
Thanks, sir. Sir.
We are present case 21 CR 1552, State of Ohio versus Ashley Bailey. Defendant was put on probation to this court. Intervention of conviction by this court back in April of 22. That was terminated on a prior probation violation. Subsequent motion to terminate community control sanctions has been filed. Scheduled for a probable cause hearing today. Defendant is here in court. She's with her attorney, Mr. Corey Hinton. Mr. Hinton, in regards to the probable cause hearing, what is your client's intention at this time?
Thank you, Your Honor. As far as probable cause, we would waive probable cause hearing, ask that the matter be set for a full hearing, and ask to be heard on bond.
So, Ms. Bailey, you have been charged with violating the conditions of your community control sanctions. There's 3 alleged violations. The first is that your Rule 1 violation. You're required to obey all local, state, and federal laws. It's alleged that you have been arrested and charged with felony charges of counterfeiting that are currently pending here in the Lake County Common Pleas Court. That was on November 5th of 2022. There's also 2 Rule 8 violations. There's actually 4 violations altogether. 2 Rule 8 violations. Rule 8 prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged on February 23rd you admitted to having used methamphetamine. And the second one ties in with the first, that previous one. It's also alleged that you submitted a urine sample on February 24th that tested positive for amphetamines, methamphetamines, and MDMA. The last is a Rule 10 violation, which requires you to submit random urine screens as requested by your probation officer. You're not to alter or tamper with the urine sample. You're not to refuse to provide a sample. And you shall not bring in with you any device, substance to simulate a urine sample, nor bring in a urine sample with you. And it's alleged on February 23rd you brought in a container which contained a substance to simulate a urine sample, and you attempted to submit that substance as if it was your own urine sample. Now, you have the right to have a probable cause hearing. That's a hearing where the state would be required to present some evidence that suggests you probably committed the violations. Now, your attorney has indicated you want to waive that hearing and get it set for a final hearing, which you have a right to also, which would be on another day, give you time to prepare if necessary, and that's a hearing where the state would have to prove the actual merits of what they're alleging. But is that right, what he said, you want to waive the probable cause hearing today?
What my attorney said, yes. Just whatever.
Very well then, the probable cause hearing will be waived. Mr. Hinton, you wanted to be heard on the matter of bond?
Thank you, Your Honor. During these proceedings, I believe that Ms. Bailey has always attended hearings as scheduled, has kept in touch with me. I do believe that she would appear at the final hearing in this matter, and speaking with her family, her parents, and significant other are here. I know they've done some brainstorming as far as trying to look at different drug treatment facilities, and are of the opinion that Ms. Bailey would be better off working towards some sort of treatment as opposed to being in the jail. So we would ask that the court set a bond that takes those items into consideration. Thank you, Your Honor.
Well, this court very, very, very rarely sets bond on probation violations. I only do that, quite frankly, when the only violation is new Bailey was out on bond right now. This new charge that she has was from November. It was brought to our attention right after she was sentenced last time, and while she could have been violated then and arrested, probation and consulting with the court decided not even to file the violation, let alone file the violation and give her a bond. We didn't even file the violation. We let her remain out. But then she decided to use methamphetamine and bring in fake urine while she was on probation. I've given Miss Bailey every break in the world here. She was initially violated the first time for something in August. Didn't violate her because she was going to school and we didn't want to take her out of school. So I told probation to hold off on that violation until she was done with school, which I don't normally do with most people, but I did that. She was then violated. She then came for sentencing. I gave her less than a week. I gave her 6 days in jail, which you know Mr. Hinton and I never do. But I did that because so she can be home for Christmas with her kids. And then we find out right after that she has new charges that she was arrested for in November that were going on while she's on probation and the other violation was pending. We don't violate her for that at that point. I give her another opportunity to stay out. And then she comes in with fake urine and using methamphetamine. So, no, Miss Bailey's not getting a bond in this case. Where she is until this gets resolved. So there's no bond being set at this time. Is there anything else for the record?
Nothing further, Your Honor.
Thank you.
All rise.